Glad you're all here, in spite of the beauty outside, the second summer we're having today and tomorrow, I think, maybe a little bit of Saturday. Want to definitely introduce you to one of our attorneys, Michael, who is going to be here teaching the seminar today. Oh, we got a whole crowd. Hey guys. Please join us. So we're going to have a seminar today, and I want to introduce some of the other team. You met Carol coming in. She's one of our admin assistants. Heather, who also is Michael's assistant. Collie we have here will be running all the slides. Amber's on the screen, and we have Jen in the back who will also be here helping us out. So I want to thank you for being here. Hopefully you will hear some things that are new to you. And also, along the way, if there's things that come up of other topics that you're interested in learning about, feel free to write that out and turn it into them. Let them know. If there's other seminars on estate planning. It's not about estate planning, I'm not sure I can help much. But if it is, we'll see what we can do. So with that in mind, I want to turn you over to Michael, and he'll be able to run this through.
Thank you. I've gotten a chance to meet a lot of you before we kicked off today, but to those who I haven't met yet, I'm Michael Smith. Welcome to our conversation today. A little bit about me. I've been in the practice of law about 18 years now, and before that I used to be a schoolroom teacher, teaching middle school students. I can handle them, I hopefully can handle this crowd. But I say that because I want to make sure that you guys are welcome to ask questions as we go. This is not just a straight presentation. I'm reading off a script to you. I want to make sure if there's thoughts or questions any of you have, feel free to raise a hand here so we can address that, okay? So you have my permission to interrupt me and keep me on the straight and narrow here as we go forward. Our topic today really is focusing on the recent tax law changes that have happened here in Washington. So we're going to be focused at the state level. These tax law changes kicked in just recently, July 1st of 2025. We may talk about some of the federal changes that are happening, but really we are focused on Washington state specific rules here. And so we've got a number of things that we're going to talk about today. We're going to start with the tax law changes, and I'm not going to assume that anyone in the room is a tax expert. I don't pretend to be a tax expert. We're here just to kind of lay out things from a nice, simple standpoint, lay a foundation here so we can learn together, and then we'll start going into how those tax laws changes may impact you. We're going to run through a couple of scenarios, hypotheticals, as to different individuals and how much their estate is worth and what that impact is going to be. So far, if I just got a quick show of hands here, we're all aware that there have been tax law changes? Okay, good. Good starting point. The information we've heard so far, are we getting that it's good news, bad news, or a mixture? Kind of good news, those hands? Bad news, raise those hands. A mixture of the two. Okay, well, a smattering of hands across the room here. So we'll try to straighten that out, whether it's good, bad, or otherwise. And then we're going to talk about, well, what do we do? We have this estate tax. It's not going away anytime soon. How do we start to manage that depending on where we fall? And we'll talk about how do we utilize our exemptions, both at the federal and the state level. We'll talk about some gifting strategies, which is one of the easiest ways we can start managing this if you fall above the taxable threshold. And we'll also talk about the way and role life insurance might play in your particular planning. And that's not the only options that exist. They only gave me so much time for the room, because if you let a lawyer talk, he'll just keep going. There's other things that we could possibly address, and we'll throw out some ideas at the very end here. So if we get started here, what is the Washington estate tax? Well, this is going to sound funny to you, but it is a tax on the right, the privilege of being able to transfer your property at the time of your death. Yeah, anytime that the government entity can find a way to tax something, they usually will. And so this estate tax is on the transfer of property at the time you pass away. It's also called an estate tax because it gets paid by your estate. It gets paid before any distribution gets made to your heirs, your beneficiaries, your kids, your family, whoever those heirs or beneficiaries may be. In other states, they call it an inheritance tax. And the tax man will come and knock on the door of those who have received something from someone who's passed away. So it's just a semantics here on the timing of when this tax gets paid as to why we call it an estate tax. How many people know where the tax money goes? We always hear about these estate taxes, and I love asking this question because most times it's to the government. Yes, that's true. What do they use it for? In Washington, the estate tax is tied specifically to the Education Legacy Trust. And that covers a wide variety of educational purposes. It covers K through 12 programs to help achieve smaller class sizes, to do some professional development training for the teaching staff. It helps students who are not yet at certain grade standards as defined by Washington State to help give them a little bit of extra support. And it also goes towards higher education within the state, colleges, universities, adult education programs. Helps with work study, financial aid. It goes to a variety of things. So sometimes I think that's just helpful in context because I don't view taxes in a monolithic way. The people that I talk to about this don't view it from one lens only. I like to joke with people that it's a spectrum. I talk to people where they say, I do not want to pay 1 red cent to the government if I don't have to. And at the other end of the spectrum, they go, I'm dead, I'm gone, it's not my problem, I don't care. And people fall usually somewhere within that spectrum. But sometimes when they hear what it goes towards, they go, okay, it's not so bad. That's not for me to decide.
It's the et cetera part.
Understood. Let's talk about who pays the Washington estate tax. Well, first of all, you gotta be dead. So I've highlighted here that it's for deceased folks here who are subject to this. You've gotta be a Washington resident who's passed away, or possibly a non-resident who's passed away but holds real estate or other tangible assets here in the state of Washington. And we have to be over a certain estate value, over what we call the exclusion rate. And that's one of the major things that has changed, and that's what we're gonna be talking about today.
I have a question about that. So if you're a non-resident and you own property in Washington, is it just the property in Washington that's taxed as part of your estate, or is it the whole estate?
That's a great question. When you get to the point and you're working with an accountant, there's a whole thing that the accountant's gonna help you do in filling out that tax return. You're gonna disclose everything, and you're gonna disclose what's in Washington. And there's a math problem that's gonna apportion it to the Washington component of those assets. Yeah.
Math problem being a percentage of the value of the real estate as a percentage of the entire estate?
Yeah, we're really gonna be focused on the Washington component of that.
Right,
But
right.
the disclosure as to what gets filed, I mean, everything gets disclosed and looked at, so.
Not just the Washington property?
Correct, correct.
So, just to clarify, you're saying it's proportionate to the value of the entire estate? Or is it in some way related to the amount that they are above the exclusion level, or?
We can talk about more specific scenarios like that at the end here, because that's gonna derail us a little bit if we get into those details at this early stage, okay? So let's talk about what has actually changed here in Washington with this most recent addition here. So we have 2 major changes that happened. So first I'm gonna start off with the good news. It's not rare, it's very rare that attorneys get to share good tax news, so we kinda like to shout it from the rooftops every chance we get to explain it. Our good news is that our exclusion amount has gone up. That means you can have more money in your estate before the taxes kick in. It used to be $2.193 million, and it had stayed at that level for a pretty good stretch of years there without any adjustments. So to finally get that number up to $3 million has been a pretty monumental change for us. The other thing that is happening with this change is they've changed how the tax exclusion amount will be adjusted moving forward. So it's $3 million to start with as of July 1st, but that number could creep upward as it gets adjusted annually for inflation. Now, the old rules were also supposed to be adjusted for inflation, and then they ran into a problem with the number that we tied that to, the metric we looked at for consumer price index and inflation statistics. They stopped publishing it. And the legislature never went back to say, well, now look at this one instead. And so instead we were stuck at 2.193. If anyone ever wondered why we got such an odd number there, that's why. But this year there's a new measuring stick. And hopefully that one sticks so we can continue to have this number go upward over time.
When did that stop, you know?
I don't recall. I
Okay.
want to say that we've been stuck at that 2.193 figure for about 8 years or so. So it was quite some time that we're dealing with that. All right. The other change that we have here, well, this is maybe the not so good news part of it. There's always a trade-off in the tax world. You get something and you give up something. And so in this situation, our tax rates have also increased. And so what was for a long time a tax rate between 10% maxing out at 20% as you climbed up in the value of your assets, well, you're still getting them to climb up over the value of your assets, but we start at 10% and now we max out at 35%. And so depending on what you're hearing out there in the media, a lot of people are focusing on this aspect. And we're gonna run through some scenarios to see how this actually impacts you, so that way you can make a decision for yourself as to, is this bad news or not so good news or otherwise? Try not to tell you how to think. We'll let you kind of think for yourselves. So let's take a closer look here. And don't be scared, it's a slide, it's got a lot of numbers and percentages on it. Sometimes that's a scary thing for some folks here, but I don't want it to be scary. I want to just make sure that we're talking the same language here. Our percentage starts at 10%, and that is for the first $1 million over the exclusion. Okay, so this does not kick in until you're over $3 million. So that first million will get taxed at 10%, under the old rules and under the new rules. And that's what we're trying to highlight here, is comparing old to new. Any questions so far? You're all with me. Haven't lost anyone as soon as we hit the number. That's a good sign. That's a very good sign. Some interesting little factors of this that you may not see at first glance here. They're all $1 million increments except for the $4 to $6 million range. This is our little aberration here where they've decided to keep the same tax rate for a wider range here from 4 to 6. And then we go back to $1 million increments until we get to 9 million, and then all bets are off. Once you hit 9 million over our exemption, now you're at the maximum rate. The other thing to pay attention to on this is, if we jump here to 9 million, it does not mean that the entire estate is being taxed at 35%. Each level receives that particular tax rate, and then we add the next level on top of it. So our first million gets taxed at 10%, $100,000 tax. That's easy math, I can do that in my head. Beyond that, we'll really see how we're doing. But if we go 2 million over the exemption, we have a $100,000 tax from here, plus 15% of whatever that next bracket is. So it's a graduated tax, okay? And that's sometimes something that people don't always realize when they see this put out. They look at the final number and they go, gosh, I'm looking at a 35% tax rate for everything. No, it's not that simple, and it's actually because of that graduation, there's a lesser tax hit than sometimes people expect.
So let's say that we're $2 million over the $3 million exclusion.
Then you're in luck. Give me about 2 slides and we'll talk exactly about that situation. So let's take a closer look at some of these hypotheticals here. My first one here is an individual with a $3 million estate. Under the old rules, they would have exceeded the 2.193 by $807,000. Does that make sense so far? Okay. I try not to go too fast when I start hitting the real math because I'll trip myself up. That $807,000 over the exemption would be taxed at a 10% under the old rules before July 1st. It would have yielded a state tax of $80,700. So that's the old rules. As of July 1st, you pass away with that same example, you are at that exclusion amount, you are not over it. So you only get taxed if you're over the $3 million exclusion or the exemption. So there's no estate tax. The tax rules changes have saved this individual $80,700 in estate tax. Good outcome for that person, okay? Let's look at our next scenario here. This is an individual with a $5 million estate. Under the old rules, we would have been about 2.8 and change over our exemption. We would have had the first million taxed at 10%, the second million taxed at 14%, and the $807,000 taxed at 15%. So you can see the graduation here. All in all, that estate tax would have been $361,050. Under the new rules, we're exactly $2 million over the exemption level. We have two levels of tax that need to be done, 10 and 15, but our estate tax is less. We've actually, this individual has saved $111,000 in tax. So if you listen to the media and you hear the headline, Washington has changed its tax laws and the rates are now 35%, you get scared. But if we dig into the details here, it doesn't mean that for everybody. It does not instantly mean your tax bill is more. In some cases, you're saving money, your estate is saving money. So I like to highlight this because when you look at the real numbers, you can make a decision for yourself as to, is this good, bad, or otherwise? You get to think for yourself here. All right, I got a couple more of these scenarios here. Now we're gonna keep going up. A $7 million estate for an individual would have had an estate tax here of $695,000 and change. There would have been 1, 2, 3, 4, 5 different degrees here that we would have to do this calculation in math. But we still, even with a $7 million estate here, we're still having a tax savings under our new rule. This is a combination. The biggest factor in this is the more that we've excluded, the tax doesn't kick in until a much higher amount. And that's the secret here. It's a combination of these two factors, the higher exclusion, that really drives most of these tax savings. All right, our last hypothetical here, an individual with a $9 million estate. A nice problem to have. Would have exceeded our previous tax exemption by 6.8 million. We would have had a little over $1 million in estate tax here at this level. And under our new rules, well, we still have a little bit more than $1 million in tax, and now we've actually seen an increase. If we dive into the details here, the break-even point where things start to tip into seeing a tax gain is roughly $8.8 million estate. But I like round numbers, it's easier to talk about, so I gave you $9 million, just so you can see that our tax bill went up by $6,670. Not a huge amount at that level. And certainly $1 million estate tax is nothing to sneeze at, don't get me wrong. But I want to show you that even though the rates have gone up, we don't see individuals getting hit with that amount until we get to much larger estates. And even at this level here, the increase wasn't backbreaking. But let's move on to our next phase here. Most of you are probably thinking all of these examples so far have been individuals. What about us married folks? I thought we had a better situation or a different situation here when it comes to estate taxes, and you do. The first thing I like to point out for folks who are married is that you have an unlimited marital deduction. You can give as much money as you possibly have to your spouse, and there will be no estate tax on that transfer from one spouse to the other. The problem, though, is if we don't use certain types of planning in our estate plan, we might be wasting one of the spouse's exemptions, that $3 million exemption. We've seen how powerful that $3 million exemption is because that's what shields us from having the estate taxes kick in. So it's an advantage that you might have, but it may not be exactly the tool you want. So one of the ways that this can be highlighted for you here is in this graph, or this chart. This is a $6 million estate. We're leaving it all to our spouse, and we're not using that spouse or the first spouse's exemption. We're just saying, let it ride, let my spouse have all of it. There's no tax at the first spouse's death. That's good news. And at the second spouse's death, we would be over the exemption level. We would have a state tax of $420,000, which means not the full $6 million to the heirs. We've got to take out that tax, the heirs get less. Okay, so this is what happens when we just leave things outright to our spouse. This is what we call the I love you plan. I love you, honey, I'm gonna give you everything. And this can be the outcome of that. But with a little bit of planning, and the planning is not hard to do, we can utilize the exemption of both spouses here to maximize tax savings. And so that's what this chart just, tries to illustrate here for you. We've got a $6 million estate. When the first spouse passes, they're not giving everything to the surviving spouse. This is, I love you, honey, but I want to help save estate taxes. And so let's put my $3 million, since I'm the one that's kicking the bucket, let's put that into a family trust. And the surviving spouse keeps his or her $3 million in their name. And so by breaking this $6 million estate up, I like to say you put one in one pocket and the other half in the other pocket. It's the same pair of pants, but we're just breaking it up. We're able to get both of these levels here to our maximum exclusion value. And if we're at that exclusion value, we're tax-free. It's only when we go over. So under this carefully selected hypothetical here, 6 million is a nice round number for this purpose. We can show that there's no estate tax here when we get down to leaving this to the kids. They're getting the full value, so they're not having kind of a tax hit for them. We good so far? All right. So far we've been talking almost exclusively about estate taxes. I'm gonna take a moment here to deviate from that because that is not the only concern people come and talk to me about. There are usually other factors involved as to why we make decisions when we craft an estate plan to include certain details, certain techniques, certain provisions. So if you look at the red here, there's other benefits to using this type of a plan, where we utilize a family trust and a surviving spouse marital trust. Sometimes estate tax is what we've been focused on, but sometimes we offer creditor protection. When the first spouse passes and we fund a family trust, this family trust cannot be sued by a creditor. So if that surviving spouse got into a car accident, or God forbid caused a car accident, and they get sued, that money in the family trust will not be touched, will not be subject to that litigation. That's a nice benefit. Predator protection. In our office, we like to warn you about the potential risks of the hunk or the bimbo. How many people have heard that phrase before? Okay, all right, so you know where I'm going with this. That surviving spouse all of a sudden hits the market, and someone looks around and they go, well, I'm gonna weasel my way in there and try to take advantage of this. And maybe I can woo them and extract some funds in the process. Well, that hunk or the bimbo who's wooing the surviving spouse will not get their hands on the family trust. It is beyond the reach of that outside predator. And so we've seen situations like this in the media and stories and TV shows and movies. Some of us have probably seen it in real life too, where the hunk or the bimbo comes in as a predator and they wipe out the estate, and who gets hurt? The heirs, usually the kids, who would have received more. So by using this, again, this structure here, we can safeguard and make sure that the spouse who's passed away, not only are we using their exemption for estate tax purposes, we're putting their half of the estate aside to protect the kids. That's where it's ultimately gonna go after the surviving spouse passes. Yes, ma'am?
So if the married couple doesn't have kids, using the family trust can still shelter part of the estate.
Yes.
But you're saying it's mostly to benefit the beneficiaries, so it's just whatever the beneficiaries are to the overall estate.
Correct. So if it's not children, it may be other family members, it may be friends, it could be anybody that is close to you that you want to benefit at that later time.
Okay,
Yeah.
so have had aging parents, who is actually making decisions for the family trust if you have that as part of your estate planning?
Great question. When you work with our team, we're gonna make sure that we talk to you about choosing appropriate trustees. So the person who sets up the trust will start off as their own trustee and manage things. When we get to this level here, it's usually the surviving spouse who's managing both of these trusts.
Okay.
But in your scenario, that surviving spouse continues to age and maybe isn't firing on all cylinders anymore. There should be alternate successor trustees named in the document who would be able to step in and continue to manage things. The trust will define that it's still for the surviving spouse's benefit. So whoever's in there has a direction to follow. We need to make sure we're managing this money appropriately for the benefit of the surviving spouse. When he or she passes, that they'll continue on to say, okay, my job is shifted now. Whoever is defined as beneficiaries at this final stage, now I've got to use these trust resources for their benefit and follow any of the instructions that were left behind for us. So it's always good to be thinking ahead as to, if it's not me, who do I trust to be the next trustee? And the more steps you can think through to identify other people around you, whether they're friends or family, you can also turn to professionals. You can get a corporate trustee to step in or a professional trustee to come in and step in and manage things for surviving spouse and the future beneficiaries. Yeah, great question, thank you. Now that we've talked about some of these benefits here, and I'm gonna kind of go back one slide, and there's one more point I wanted to make here. So we talked about saving estate taxes, saving against creditors and predators. The beneficiary protection, I kind of alluded to, but I wanted to make sure I emphasize. Using this structure can also make sure that the beneficiaries we want to designate, or the first spouse who passes, it could be a blended family. It could be his kids and her kids, and whoever's passing away first. We don't want order of death to all of a sudden yield a jackpot for one half of the family but not take care of the other. And using this kind of a strategy here can also make sure that you're taking care of who you want to include in your plan. And whether you pass first or second, it's baked into your plan that you're gonna be protecting them. Okay, so there's other benefits to using this type of a structure, this type of an approach, and it's not all tax driven. Okay, so even though our conversation today is focused on the benefits or the changes that are happening under Washington tax laws, there's a lot of other factors that we want to talk to you about when evaluating your approach and what your needs are to help you get to the outcome that's right for you. Okay. Now we'll move ahead and talk about some of our strategies. How do we start managing this if we fall above that exclusion amount? And if you are saying to yourself, I'm not thrilled about funding the legacy, the education legacy trust. I'd rather control this and not have a tax bill for my heirs or for my estate after I'm gone. One of our starting points here is talking to you about gifting. Accelerate the inheritance that you might be giving to kids or friends or other beneficiaries. Give during your lifetime. And so by giving it away now, you're reducing the value of your estate. If you look at see how far over am I, and you come up with a strategy to give to a large group of people, that'll start bringing you down faster. If you've got a smaller group of people, well, maybe you're gonna be giving over a longer period of years. Whatever works for you, okay? So this is just sort of a reminder here. Our exclusion at this year is $19,000. A person can give $19,000 to as many people as they want, related or otherwise. I spell Michael M-I-C-H-A-E. Okay, no, I'm just kidding. Couples can give $19,000 each to the same beneficiary. So they can give it to their, both can give to their son, both can give to their daughter, et cetera, double their gift. So that's $38,000 that you can use to start getting that out of your taxable estate. And you can do this on an ongoing basis. Now, I throw this number out here because that's our limit before paperwork kicks in. You can give as much as you want, okay? So let's say you give a $50,000 gift to somebody. That's fine. You're not paying any taxes on that, and the person receiving it isn't paying any taxes on that either. Because we're over this $19,000 threshold, all it means is we now have a paperwork requirement that we've got to file a gift tax return on our next tax return so that we can keep track of how much have we given during our lifetime. Now, Washington does not have a gift tax. The feds, they have a lifetime gift tax that they're paying attention to, and that's about almost $14 million right now. So you can start registering what you've given above this $19,000, and we'll start counting towards that lifetime gift amount. But if you stick to 19 or less, you have no paperwork requirement, and it doesn't start to utilize your lifetime gifting levels.
I have a question.
Please.
Technical question about this. So if a parent were to pay off a mortgage without giving it directly to their child, but just pays their mortgage off so that they don't have a mortgage payment
Yeah.
anymore, is that considered a gift legally?
I think we're definitely looking at that as a gift. I would be looping in an accountant to see if there's some other view that they could have to examine it in a different way.
Cause there's no documentation on that amount of money going to
Yeah.
the individual.
It's for the benefit of, and that's where we start getting into a trickier area. Although the person didn't receive the money, they didn't
Correct.
turn around and pay the mortgage with it.
Correct.
It was used for that person's benefit.
Right, the parent directly paid the
Yeah.
financial institution
Yeah.
so that.
The only time where we start making payments for someone else's benefit and we don't have this concern really focuses on education. If we wanna pay someone's college expenses or grandkids' college expenses, that's a great way to do it. We can also do it in healthcare situations as well, but I don't believe we can carve out a mortgage payment like that. But I'd also loop in a CPA just to make sure I'm not missing something on that.
Okay.
Yeah, okay, let's move ahead here. The advantages and disadvantages of gifting. We talked about a little bit about this, but we'd like to highlight it here. The point we're doing by gifting is we're trying to reduce the size of your taxable estate. The more you give away, the less money you have. Pretty basic. Also, as you're giving assets to kids or whoever, you may be giving them assets that might continue to appreciate in value over time. You might be giving them stocks or real estate or something else. And so that appreciation that is potentially there with that asset is also coming out of your estate. And that's a way of kind of leveraging your gift where it may have a larger impact to the recipient. You can also start using this as a test, measure the responsibility level of certain recipients. What would you do if I gave you $19,000? Are you gonna use it wisely and put it towards the purchase of a home or pay off some student loans, or, oh, you went to Vegas and you put it all on the roulette table? Okay, well now I know where your responsibility level is with money, and that might influence what I do in the future. Maybe I need to sit down with you and guide you as to maybe what a wiser use of funds could be. Or let me introduce you to this financial advisor who might be able to, you maybe don't need to hear it from dad, you need to hear it from someone else who may have a larger impact on you. So this is sometimes also a way just to kind of figure out, is this the person I want as my future trustee who's gonna manage things for me if I become impaired or incapacitated? And you can kind of get an early glimpse of what your team around you looks like. The other advantage is, it's also just more enjoyable to give it away while you're alive. Let you see the reaction. Let you see someone use this gift in a way that might change their lives. Yes, I'm gonna send you on a vacation and pay for you to go do a grand tour of Europe and you know, open your eyes as a high school graduate or college graduate. That's a great time to kind of let someone experience travel and see the world for whatever that might mean to you. That's just one example. Now, there's different disadvantages with gifting to be aware of. Anytime we give an asset, we give basis in that asset. What's basis? Okay. More tax talk. Got to break that down. When we first acquire an asset, think of a house. The price we pay for that asset, that's our starting point. That's our basis. If we sell that asset years later and there's been gain involved, well, we subtract the basis from the sale price, and that's our measure of gain, and now we're looking at a capital gain situation. So earlier I talked about maybe we give assets that might appreciate in value. If we give those assets, we're also giving them our starting point, we give them our basis, and we might be giving a capital gains tax problem to somebody. So we have to pay attention as to whether that's what we want or not, whether that's the right move. And if we give that asset away, we miss the opportunity to get a step up in that tax basis when we pass away. So sometimes people will come and they say, Michael, should I give my house to my kids? Well, what are your kids gonna do when they receive it? Well, they're gonna sell it. They don't wanna live there. Okay, well, now you're giving them a capital gains tax problem. So if you'd rather them not have that, you don't need to give them the house. Pass away owning the house, let them receive it then. Now they get it at fair market value with a stepped up basis. They can sell it at that point and not have a capital gains issue. There's nuance here. Far more than we can just cover in a few slides here. This is where you want to kind of meet with somebody and talk it through for your own situation. And then the most obvious disadvantage of gifting is, if I give it away, I don't have it anymore. Sometimes I need to say that because people will just assume, well, they'll give it back. We can't require them to. We have to think of a gift as a completed gift. It's out of my hands, it's gone. I don't have it to use anymore.
Can I say one thing about that?
Please.
You can have, medical things kind of happen with the blue. So we had friends that had gifted, down payment amounts for their kids. And then they had one of the people had a very severe medical issue where they had the choice of either going on Medicaid, not Medicare, Medicaid, but in order to do that, they would have had to have asked for the gifts that they'd given their kids, and they didn't have a way to pay those back.
Yeah.
So, there's that to consider, when you say they can't give it back, there's other things that happen in life that can.
And that's going down a very particular path of the Medicaid program and a 5-year look-back window and very intricate rules here. That's gonna be beyond the scope of our conversation today, but there are some things to consider when evaluating whether to be making gifts. What is your goal behind that gift? Right now, we're talking about the goal being to try to diminish our estate to avoid estate taxes. Sometimes people are using that as a way to qualify for Medicaid, but that's beyond our conversation today. All right. We have different types of gifting that we can do. Sometimes we're giving gifts when they have strings attached to them. I'm gonna give you this much money when you graduate from college. And there's some condition that has to be met before they receive it. Sometimes the most common gift is, I'm giving you a gift right now, it's present value, and I'm writing you a check, $5,000, here you go. That type of a gift, that's what we focus on when we're talking about that $19,000 annual exclusion. Giving money right away, they can use it, and it's theirs, no strings attached to it. There's also a gift of future interest, and this is where things get tricky. Sometimes it's, I'm gonna put money aside for you when you turn a certain age. Well, that's not a present gift. We haven't given the value right away. So that doesn't apply for our annual exclusion unless we do something that's called a crummy power or a crummy letter. This is a weird term, okay? Crummy comes from a name of an IRS case that went through all different court proceedings here to figure out how do we get to use this idea of giving a future gift, but somehow converting it so that it's a present day value and applies to all these other things. What this really is I'm gonna let you know I'm giving you this gift. You have the ability, you have a small window of time to start using the money right now if you want it, but I don't want you to do that because it's better if you use this money in the future. But I'm giving you this right to use it for this short period of time, and if you choose to do it, well, that's on you and you're missing out on a bigger advantage. It's nuance, but it's a legal requirement that we will build into certain types of plans and make sure happens in order to kind of get the tax advantage that we want, but kind of have our cake and eat it too. All right. Charitable planning. I think charitable planning is great. Yes, sir.
I'm sorry, back on the previous slide where you talked about present interest and future interest.
Yes.
That's not interest in the sense of interest on an investment.
Correct. Yeah, I'm not talking about like an account is earning so many percentage points of interest a year. No. What I'm saying is if I give you that $5,000 check and I hand it to you right now, that is yours presently to use, and you can do whatever you want with it. If I were going to give you, if I were to put $5,000 aside for you in an account that you can only access 5 years from now, you don't get to use that money. You only get to use it in the future. That would be an example of future interest in that $5,000.
But does it still get it out of your estate then?
When you are giving it right away,
No, but if you give it with that future date in mind, is it presently out of your estate?
if I have a crummy power and I say, you have a short period of time to use this 5,000 for some purpose, but if you don't exercise that, it's gonna go towards a future purpose, which may be more beneficial to you, that's where we start to get that ability. Yeah.
Okay, so then they're both
I wanna
deductible from
be
the
sure I
estate.
As long as you are complying with these little nuances.
The crummy letter does, in essence, put it out of your estate, whether or not the recipient uses it or delays
Yes,
the possession.
yes. The recipient is getting to decide if they're gonna use it right now,
Okay,
even though that's probably not what your goal was.
Right.
Your goal in giving it as a future interest was, I want this to apply for something in the future, college expenses, down payment. I'm gonna keep making these gifts to you because I wanna get it out of my estate, but I don't really want you paying it right now because maybe I have that trip to Vegas in the back of my mind where you screwed up before and I don't wanna do that again. But you're right, it's the recipient's actions who are gonna decide whether that becomes a present or a future interest.
Year,
Yeah.
future year, right? Cause it's an annual amount.
Well, it doesn't have to be annual, it could be a one-time thing. Yeah. All right, so back to charitable plan. This is just a way of giving to a cause, an organization, something that you believe in and wanna support. Charitable causes are great, they are designed to outlive the human lifespan. And so sometimes people get to the point in their estate plan where they go, I don't know who to leave things to. Well, what do you like to support? Is there a church, a cause, an organization, a charity, a school? The world's your oyster. You can go out there and put your money behind something that's gonna leave a legacy that's important to you. And so charitable planning is great to include. When you make a gift to charity, right now, you might be writing a check to charity, you're again reducing the value of your estate as if you were giving it to a child or other friend or family. When you include that charitable gift as part of your estate plan, as part of your will or your trust, that charitable gift can also reduce the amount of your estate tax bill because it offers a deduction against the estate tax that your estate might be charged. So, if you were a taxable estate and you wrote a $500,000 check to, or your estate was directed to write a $500,000 check to the Boys and Girls Club, that was recently featured on the Emmy Awards, the charity of choice for that evening. Great, it does great work for an organization, and now that $500,000 check serves as a deduction when you go through the process of filing an estate tax return that will help to decrease the level of estate tax your estate might have to pay. When estate tax rules were first kicked off, our tax rate was from 1 to 10%. Our current federal estate tax rules kick in at 40, or max out at 40%. And we talked a little earlier about Washington State is now between 10 and 35%. So whether you choose not to make a charitable gift and you have a taxable estate, we've already outlined that you've got money going to the Washington Education Legacy Trust, which is going towards certain causes. So you may have a charitable component to your estate plan if you don't plan for addressing it yourself, or you could get out in front of it and choose organizations that you do want to support, because we might be worried about the et cetera that was listed on the earlier slide. You get to come back and say, I don't want to have et cetera. I want to name these causes, these organizations. This is what matters to me. It's your world. It's your estate plan. We're here to help guide you through that. Now, the last topic here we're going to talk about here is life insurance and how that might fit into your particular situation. Life insurance serves a lot of different purposes. So in the estate planning world, we might be using it to create a pile of money that didn't exist before. And we may be using that pot of money to equalize gifts between different family members or different beneficiaries. So we might be using it to equalize, to make sure that although I'm giving you a house, I want to leave something of similar value, and so I got to create a pot of money using a life insurance policy. We also see life insurance policies get used when someone owns a business. Sometimes that business might have a provision inside it that says, well, my partner is going to buy out my interest, but my partner needs a pot of money from somewhere to all of a sudden do that. So let them take out a life insurance policy on me and they use those proceeds to pay my family the value of what my interest is, and they end up walking away with the business, and they can go off and continue to run the business for years. Life insurance is also great to just replace income after someone passes away. If your spouse is the wage earner, we want to protect against all of a sudden their disappearance and their wages disappearance. So it serves that purpose as well. And then sometimes it serves as wealth replacement. And what that can mean is we are using this pot of money to create a revenue stream because we know we may have an estate tax. So let's create a pot of money so we've got the money available to write a check and pay our estate tax. And so it replaces the wealth that was in our estate with another new revenue so that we're not missing out on leaving what we had hoped to our heirs and our beneficiaries. Now, life insurance also usually carries with it a couple of misunderstandings, so things that we like to clarify and come back to. Is life insurance tax-free? Is the question that we normally get. Well, you didn't earn it when it gets paid out, so it doesn't get subject to any income tax. So from that standpoint, we're free of income tax. But today we've been talking mostly about estate tax, and this is where you get the typical lawyer answer is, well, now it depends. Okay, we love hearing that. We love saying it too. It depends on whether this is going to be subject to estate tax, largely based on how does that life insurance policy fit into the plan. If you own the policy directly or indirectly, and you pay the premiums on that policy, either directly or indirectly, and retain what we call the incidence of ownership, well, now it's part of your estate. You own it. It's one of your assets. And so we're gonna list that on the tax return, and it's gonna be taxed. But if you didn't retain the ownership of that, perhaps you use something called an irrevocable life insurance trust or an ILIT. And this trust took out the policy on your life. And when you passed, the money got paid to this trust. Well, it's an irrevocable trust that I gave up control over it. It's not something that I had the ability to maintain ownership of. And now that gets excluded from my estate. This is a little bit more of an advanced level technique. It comes up in a lot of situations. So let's dive in a little bit closer and look here at what an ILIT, why we have it, and how we create one. We use this type of an approach just to intentionally keep an insurance policy beyond our reach and outside of our estate so that it will not be taxed when we pass away. It helps to increase our insurance coverage. One of the ways that we do that is we are giving money to this trust, part of our annual giving. Okay, that money that goes to the trust then turns around and they use that money to pay the premium on the policy. So one, I get to decrease the size of my estate by giving money to this trust, and then that trust turns that money into a life insurance policy that will get paid out when I pass away. So we're kind of getting two benefits there.
Are the premiums subject to that 19,000 gift allowance?
The premium will be just based on what you qualify for.
Right,
so
right.
whatever kind of policy is being shopped for at that time, the premium's gonna be what it is. But when you start giving,
if they exceed 19,000,
then you're gonna have to report that. Yes.
Gotcha.
Okay. And so that's also another area where we're using these crummy letters, what we talked about earlier. We're saying the trustee, especially if we give more, they could be using that money presently to do something, but if they don't use it for that purpose and it gets used for the policy, the premium policy payment, even better. And now when we use this trust, we also define who's going to be the beneficiary of that trust in the future. So we get to direct where that life insurance policy is going to do good in the world. Whether that's going to be our friends, our family, or just being used to pay estate taxes as a wealth replacement strategy. Lots of factors to take into consideration here.
So you can put the gift into the ILIT. The ILIT pays the premiums for the life insurance policy.
Yep.
And then the beneficiary of the life insurance policy is the trust, is that correct?
Yes, and then the trust has language as to who receives those funds when that policy pays out.
Who and when?
Yes. Yes. All Alright, so we can use those funds to pay death expenses, and that's one of the most common uses of that. Our next slide here goes into a little bit of overview here of how do we create one of these items. We first have to sign a trust document that spells out all the details of what we want. The trustee of that trust, who is not the person who set it up, it's gotta be someone different, they're gonna go out and they're gonna get a tax ID number. They're gonna sign up to get that life insurance application done so we can secure a policy. They're gonna open up a checking account using that tax ID number. And now the person who's setting up the trustor is going to now give money to the trustee. That trustee is gonna now give that crummy notice to the beneficiaries of whoever's gonna end up receiving that policy benefit, whether that's the kids or someone else. And if they don't exercise the right to take that money and go to Vegas, and they decide that instead, let's not take it right now and have a future benefit from it, now they'll take that money and they'll pay the premium. And so now that small investment, which could have been a nice trip to Vegas, might turn into several $1 million life insurance payout in the future. So delayed gratification is sometimes a hard lesson to teach, but it's oftentimes very impactful if we can get them to learn it. And then our next slide here will also kind of show you the idea here of how we might use these annual gifts depending on how many beneficiaries might be involved in that trust. To kind of go to your earlier question of, are we capped at that 19? Well, let's look to see how many beneficiaries are involved. We can multiply that gift then by each of those beneficiaries to put a larger premium payment into the pot, okay? And we use those premiums, we go out and hypothetically we're to find $1 million policy, could be more. It all depends on what you qualify for. So a lot of information here on life insurance, probably more than you expected when you walked through the doors today, but this is one of our strategies for potentially dealing with an estate tax. It's not our only option, gifting isn't our only option, and this is just a slide here that kind of talks about some of the other, maybe more advanced techniques that don't apply to everybody. If you're curious about them, we welcome you to schedule a time to sit down and talk to one of us to kind of see whether this is the right fit for you. There are other types of irrevocable gifts or irrevocable trusts that could be set up where you're getting money out of your taxable estate and you're giving it away to somebody else with terms and conditions that you select. You may have a charitable intention. You may want to put money aside for a charity that they will receive it in the future, and use of a charitable remainder trust. Grantor annuity trusts are ways that you're giving money away. Someone else will receive it in the future, but you're going to retain an income stream from it over time. People like to think about giving away their property, the house that they're living in, so that it goes to the kids at one future point in time to get that value of the house out of their estate. But with each of these, there's more details that we can quickly cover in a couple of slides here. We don't want to give it short service here. That's really something that's better suited for personalized conversation and consultation. So that brings me to the end of all the material that I wanted to share with you today. Let me open it up to see, are there questions that anybody has? Or did I knock you all out with graphs and charts of numbers and math problems that you've all fallen asleep?
One question, if, somebody wants to, when they die, create a trust for a child who maybe has long-term health problems, is gonna need it, so they don't want anybody to be able to come after it.
Yeah.
And, what are those trusts called?
They go by a couple of different names. They're often referred to as a special needs trust or a supplemental needs trust. Either way, they're abbreviated SNTs. And that's a particular area where we're trying to, again, qualify an individual, or an individual may already be qualified for certain government assistance programs. We don't want an inheritance to all of a sudden wipe out their qualification. So we have special parameters for how that money is held, how it's used, to make sure that they continue to qualify.
But that has to be set up, so when the, parent dies, then it goes, and or can the SNT be set up before they pass?
It can be set up while someone's alive, so if you wanted to set one up for an individual that you knew, yes, you can do it during lifetime. Some people choose to do it as part of a will or a trust, so it only gets into existence after they pass away. Either approach is acceptable. You just look at circumstances to figure out what might work better. Yeah, good question. Yes, ma'am.
With an ILET, are all aspects of that policy irrevocable, like permanent beneficiary exemption, or other aspects of the policy be changed as
Yeah.
they go by?
Whenever we're talking about a trust that's irrevocable, we really mean irrevocable. You really can't make adjustments on the fly. You have to really sit down and think through a lot of what-if scenarios to say, once I release this out into the world, if these things happen and go wrong, do I still get the same outcome that I'm hoping for? Or is it redirected in some other way to achieve an outcome I like? But you can't come back in and say, oh, that didn't work. Let's
So-
go back and scratch this and try it again.
So now your trust document then would be a separate thing from the actual life insurance policy that has beneficiaries listed in it, but the trust that controls what happens with that life policy?
The trust are the instructions that you're leaving to your trustee. The trustee will follow those instructions, use the money that is paid into the trust after giving crummy notices to then go out and find the policy that's gonna work. So you have a high degree of trust in that individual that you're selecting to do the right thing to make it work out for you.
So I have a little different scenario. What about people who set up an ILET when estate taxes were lower, and they really no longer have the need for that policy in the same way that they originally did? Because they now don't have a taxable estate.
Yeah. And that's one of the factors that they should hopefully have taken into consideration when setting it up, because it could be used for the idea of paying an estate tax, but ultimately, where is it gonna go afterwards? And hopefully it's going to the beneficiaries that they were intending to support or benefit, that now they're just receiving it as a windfall.
Oh, they don't have to use it for taxes, they can use it.
If there's no tax bill to pay, now they get to use it the way they want to as they receive it. Yeah.
And part of that to be aware of is in a life insurance trust, it actually does not pay the taxes directly.
Pays.
With a life insurance trust, it's a wealth replacement. It would buy an asset from the estate plan, so the estate plan has liquidity, and then the assets go down to the beneficiary. You do not want to notify the IRS, hey, there's a life insurance trust over here. So this side pays the taxes, and over here, it replaces the wealth that did go out. If it turns out that there's no estate taxes, what are the beneficiaries?
So,
But you silo
the
the
estate pays the tax,
Yes,
and then the policy replaces what the estate
absolutely.
paid. And if the estate doesn't have the liquidity to pay the taxes?
That's why it buys an asset. A life insurance trust can buy an asset, so you don't have to do a fire sale on a business or on a piece of property.
So the federal tax ID for the trust is for the gifting into the trust, is that
So it has
correct?
a bank account, so it can
Okay.
set up a bank account in the name of that island.
The irrevocable trust.
But as far as any type of tax returns or anything like that for the trust, you don't have to file anything separately for that, for the ILIT?
That depends. Some of our ILETs have been filled up with a large amount of money. They make an initial payment into the life insurance trust. It might purchase an annuity that every year the payment from the annuity pays the life insurance policy. In that case, there is income inside the trust. If it goes over the threshold, then you do file a 1041. And there are times also, you can make a life insurance policy a beneficiary designation to a special needs trust. If it's an irrevocable, standalone, or a testamentary, you can still do the same. Okay, we have about 20 minutes more,
Okay.
which is good. And sometimes we've had people come to these seminars that, like this, have questions not related to the topic, but we're hoping to ask them. So if you need to leave or stand and talk to one of us, feel free. But are there other questions that any of you did come with today?